Welcome to the appendix, where we read the primary sources of the past so that the present can be better understood. Today's primary source, Massachusetts Bill of Rights, 1780. The Constitution of Massachusetts of 1778 had contained no Bill of Rights. When submitted to the vote of the freemen, it was defeated by an overwhelming majority. John Adams was the chief architect of the Constitution of 1780. He was responsible for the whole of the Bill of Rights, with the exception of the article on religious freedom. The end of the institution, maintenance, and administration of government is to secure the existence of the body politic, to protect it, and to furnish the individuals who compose it with the power of enjoying in safety and tranquility their natural rights and the blessings of life. And whenever these great objects are not obtained, the people have a right to alter the government and to take measures necessary for their safety, prosperity, and happiness. The body politic is formed by a voluntary association of individuals. It is a social compact by which the whole people covenants with each citizen, and each citizen with the whole people, that all shall be governed by certain laws for the common good. It is the duty of the people, therefore, in framing a constitution of government, to provide for an equitable mode of making laws, as well as for an impartial interpretation and a faithful execution of them, that every man may, at all times, find his security in them. We therefore, the people of Massachusetts, acknowledging with grateful hearts the goodness of the great legislator of the universe, in affording us, in the course of his providence, an opportunity, deliberately and peacefully, without fraud, violence, or surprise, of entering into an original, explicit, and solemn compact with each other, and of forming a new constitution of civil government for ourselves and prosperity, and devoutly imploring his direction in so interesting a design, do agree upon, ordain, and establish the following Declaration of Rights and frame of government as the Constitution of the Commonwealth of Massachusetts. Part the First. A Declaration of the Rights of the Inhabitants of the Commonwealth of Massachusetts. Article 1. All men are born free and equal and have certain natural, essential, and unalienable rights, among which may be reckoned the right of enjoying and defending their lives and liberties, that of acquiring, possessing, and protecting property, in fine, that all seeking and obtaining their safety and happiness. 2. It is the right, as well as the duty of all men in society, publicly, and at stated seasons, to worship the Supreme Being, the great Creator and Preserver of the universe. And no subject shall be hurt, molested, or restrained in his person, liberty, or estate, from worshiping God in the manner and season most agreeable to the dictates of his own conscience, or for his religious profession of sentiments, provided he doth not disturb the public peace, or obstruct others in their religious worship. As the happiness of a people and the good order and preservation of civil government essentially depend upon piety, religion, and morality, and as these cannot be generally diffused through a community, but by the institution of the public worship of God, and of public instructions in piety, religion, and morality, therefore to promote their happiness and secure the good order and preservation of their government, the people of this commonwealth have a right to invest their legislature with power to authorize and require, and the legislature shall from time to time authorize and require the several towns and other bodies, politic or religious societies, to make suitable provisions at their own expense for the institution of the public worship of God and the support and maintenance of public Protestant teachers of piety, religion, and morality. And the people of this commonwealth do invest their legislature with authority to enjoin upon all the subjects and attendants upon the instructions of the public teachers aforesaid. And every denomination of Christians, demeaning themselves peacefully and as good subjects of the commonwealth, shall be equally under the protection of the law, and no subordination of any one sect or denomination to another shall ever be established by law. 4. The people of this commonwealth have the sole and exclusive right of government themselves as a free, sovereign, and independent state, and do and forever hereafter shall exercise and enjoy every power, jurisdiction, and right, which is not, or may not hereafter be, by them expressly delegated to the United States of America in Congress assembled. 5. All power residing originally in the people and being derived from them, the several magistrates and officers of government vested with authority, whether legislative, executive, or judicial, are their substitutes and agents, and are at all times accountable to them. 6. No man, nor corporation, or association of men have any other title to obtain advantages, or particular and exclusive privileges, distinct from those of the community, than what arises from the consideration of services rendered to the public, and this title being in nature neither hereditary nor transmittable to children or descendants, or our relations by blood, the idea of a man born a magistrate, lawgiver, or judge is absurd and unnatural. 7. Government is instituted for the common good, for the protection, safety, prosperity, and happiness of the people, and not for the profit, honor, or private interest of any one man, family, or class of men. Therefore, the people alone have incontestable, unalienable, and indefensible right to institute government and to reform, alter, or totally change the same when their protection, safety, prosperity, and happiness requires it. 8. In order to prevent those who are vested with authority from becoming oppressors, the people have a right at such periods and in such manner as they shall establish by their frame of government to cause their public officers to return to private life and to fill up vacancies, places by certain and regular elections and appointments. 9. All elections ought to be free, and all the inhabitants of this commonwealth, having such qualifications as they shall establish by their frame of government, have an equal right to elect officers and to be elected for public employments. 10. Each individual of the society has a right to be protected by it in the enjoyment of his life, liberty, and property. No part of the property of any individual can, with justice, be taken from him or applied to public uses without his own consent or that of the representative body of the people. And whenever the public exigencies require that the property of any individual should be appropriated to public uses, he shall receive a reasonable compensation therefor. 11. Every subject of the Commonwealth ought to find a certain remedy by having recourse to the laws for all injuries or wrongs which he may receive in his person, property, or character. He ought to obtain right and justice freely, and without being obliged to purchase it completely, and without any denial, promptly, and without delay, conformably to the laws. 12. No subject shall be held to answer for any crimes or offense until the same is fully and plainly described to him, or being compelled to accuse or furnish evidence against himself. And every subject shall have a right to produce all proofs that may be favorable to him, to meet the witnesses against him face to face, and to be fully heard in his defense by himself or his counsel at his election. And no subject shall be arrested or deprived of his life, liberty, or estate, but by the judgment of his peers or the law of the land. And the legislature shall not make any law that shall subject any person to a capital or infamous punishment, except for the government of the army and navy without trial by jury. 14. Every subject has a right to be secure from all unreasonable searches and seizures of his person, his houses, his papers, and all his possessions, and no warrant ought to be issued but in cases and with the formalities prescribed by the laws. 15. In all controversies concerning property, and in all suits between two or more persons, the parties have a right to a trial by jury, and this method of procedure shall be held sacred. 16. The liberty of the press is essential to the securing of freedom in a state. It ought not, therefore, to be restricted in this Commonwealth. 17. The people have a right to keep and to bear arms for the common defense. And as, in time of peace, armies are dangerous to liberty, they ought not to be maintained without the consent of the legislature, and the military power shall always be held in an exact subordination to the civil authority, and be governed by it. 18. A frequent recurrence to the fundamental principles of the Constitution, and a constant adherence to those of piety, justice, moderation, temperance, industry, and frugality are absolutely necessary to preserve the advantages of liberty and to maintain a free government. The people ought, consequently, to have a particular attention to all those principles in the choice of their officers and representatives, and they have a right to require of their lawgivers and magistrates an exact and constant observance of them in the formation and execution of the laws necessary for the good administration of the Commonwealth. 19. The people have a right, in an orderly and peaceable manner, to assemble, to consult upon the common good, give instructions to their representatives, and to request of the legislative body, by the way of addresses, petitions, or remonstrations, redress of the wrongs done them, and of the grievances they suffer. 20. The power of suspending the laws, or the execution of the laws, ought never to be exercised but by the legislature, or by authority derived from it, to be exercised in such particular cases only as the legislature shall expressly provide for. 21. The freedom of deliberation, speech, and debate in either house of the legislature is so essential to the rights of the people that it cannot be the foundation of any accusation or prosecution, action, or complaint in any other court or place whatsoever. 22. The legislature ought frequently to assemble for the redress of grievances, for correcting, strengthening, and confirming the laws, and for making new laws, as the common good may require. 23. No subsidy, charge, tax, impost, or duties ought to be established, fixed, laid, or levied under any pretext whatsoever, without the consent of the people, of their representatives in the legislature. 24. Laws made to punish for actions done before the existence of such laws, and which have not been declared crimes by preceding laws, are unjust, oppressive, and inconsistent with the fundamental principles of a free government. 25. No subject ought, in any case or in any time, to be declared guilty of treason or felony by the legislature. 26. No magistrate or court of law shall demand excessive bail or sureties, impose excessive fines, or inflict cruel or unusual punishments. 27. In times of peace, no soldier ought to be quartered in any house without the consent of the owner, and in time of war, such quarters ought not to be made but by the civil magistrate in a manner ordained by the legislature. 28. No person can in any case be subject to law martial or to any penalties or pains by virtue of that law, except those employed in the army or navy, and except the militia in actual service, but by authority of the legislature. 29. It is essential to the preservation of the rights of every individual, his life, liberty, property, and character, that there be an impartial interpretation of the laws and administration of justice. It is the right of every citizen to be tried by judges as free, impartial, and independent as the lot of humanity will admit. It is therefore not only the best policy, but for the security of the rights of the people and of every citizen, that the judges of the Supreme Judicial Court should hold their offices as long as they behave themselves well, and that they should have honorable salaries, ascertained and established by standing laws. 30. In the government of this Commonwealth, the legislative department shall never exercise the executive or judicial powers, or either of them. The executive shall never exercise the legislative and judicial powers, or either of them. The judicial shall never exercise the legislative and executive powers, or either of them, to the end it may be a government of laws and not of men. Thank you for joining us for our primary source today on the appendix. We will see you in the stacks.